Hello, everybody. Welcome to day 13 of the Level Up Symposium. My name is Andrew Scriver, and it's my pleasure to welcome you to Intellectual Property in a Digital Era, presented by the Associated Designers of Canada with support from Toaster Labs Mixed Reality Performance Atelier. I am one of the co-curators of the symposium and a member of the ADC, and I'm very happy to be your host for this event. I would like to first acknowledge that I'm coming to you from the Tiohtià:ke, which is the unceded land of the settler city of Montreal, which is and was, long before colonizers arrived, a place of conference, conflict, and creativity for many Indigenous peoples, including the Kanien'kehá:ka, the Anishinaabe, the Huron-Wendat, and the Abenaki peoples. I'm honored and humbled to be able to be here to share and create with you all, and so I offer my thanks. In this spirit of gratitude, I would like to acknowledge the support of the Canada Council for the Arts, the primary supporter of the symposium as a whole, as well as our other sponsors, who are IATSE, the University of British Columbia, Theatre Alberta, CITT Alberta Chapter, Concordia University, Ryerson University, York University, and of course, our individual donors. Thank you all very much. So for your information, all symposium events will be recorded and presented in a freely available archive on our website within a few days of the event. So thank you everyone, attendees, for joining us today. You're watching this live stream either on the Level Up website, which is levelup.designers.ca, on HowlRound through our partners at Toaster Lab, or on the respective Facebook pages of the ADC or Toaster Lab. Regardless of your viewing platform, embedded on the same page as the video in the top right-hand corner is the chat function. So you can click on the little chat bubble and ask questions at any time, which will then be asked to the presenter as they go. This event can be enjoyed through auditory or visual access, or a combination of both, and all questions will be read aloud by the presenter herself from the chat, and the information will also appear visually on the bottom of the screen. Visual access is also supported with captioning for myself and captioning for all of our presenters in the archived version of the presentation. So if you require technical assistance at any point to support your access, please email levelup@designers.ca for immediate support, or to, of course, provide feedback following the events. If you enjoyed this session or any of the sessions during Level Up, please consider donating any amount that you can to the Associated Designers of Canada to support our National Arts Service Organization in achieving its goals of advocacy, mentorship, and industry promotion. Donation links are available on all viewing platforms on our website, on the ADC's website, or canadahelps.org, so please consider donating. Thank you for your patience with all of our announcements. So it is now my honor to welcome our presenter of this event, the Vice President of the Board of Directors of the Associated Designers of Canada, and an award-winning lighting designer in her spare time, Kim Purtell. Welcome, Kim.
Hi, thank you so much, Andrew. Hi, everyone. Thank you so much for joining us today. And thanks for taking the time to listen to some information I'd like to share with all of you. As Andrew said, I'm Kimberly Purtell. I am the Vice President of the Board of the Associated Designers of Canada, and I have held that position for a number of years. I've been primarily a lighting designer, but also set designer for about 22 years. I've been a member of the Associated Designers of Canada for 8 or 9 years. I can't remember exactly, especially with pandemic. Seems like time is elastic. And since the time of me becoming a member of the Associated Designers of Canada, I have also been on the board. Over the last few years, I've become very well acquainted with our contracts and with understanding all the aspects of a designer's contract, and very importantly, with intellectual property. So something I didn't understand quite fully, and something that I find are the greatest number of questions that come to us as a board, and to myself very specifically, is questions regarding intellectual property. So intellectual property for designers is your design. So if I am designing the lights for a show, all the cues that are involved in the show are my intellectual property. This is the art that I have created. it's arguable that the plot in the air is not my intellectual property. It is the use of that plot. The drafting of that plot is my intellectual property. For a set designer, a 4x8 flat is not your intellectual property. The set as a whole is your intellectual property. So recognizable pieces of the set cannot be reused without alteration or your permission, let's say. A costume designer, their sketches, the realization of their costumes is their intellectual property. The use of the costumes in the production as a whole is their intellectual property. However, one skirt, unless incredibly recognizable to the show, is something that could be, let's say, used in another production. We were having a discussion with a designer recently, well, a number of months ago, with regards to a prop. I think it was a dragon, I can't remember exactly, that was very specific to built very specifically for a show. That is her intellectual property. So design as a whole, your design as a whole going into a production is your intellectual property. Before I move on and talking about intellectual property when it has relationship to your contracts, to the end of a contract, to royalties, etc., does anyone need clarification on understanding what a designer's intellectual property is? If you have a question, just throw it in the chat. If not, I will continue. Okay. It looks good for me to continue. I do understand that there are probably a number of people on this call who are not members of ADC, but first and primarily, I'm going to talk about the contracts that exist with ADC. So ADC has a collective agreement with PACT, which is the Professional Association of Canadian Theatres. We also have an Indie 1 and an Indie 2 contract. All three of the, and we also have an agreement with the NEC. All of the contracts that that the ADC has have standards, terms and standards that accompany the contract. Within that, there is quite a large explanation on intellectual property and how you are the owner of your intellectual property, and its lack of transferability. So when you sign a PACT contract or an Indie contract, that contract has an expiration date of 3 years. So within that contract, you will have been paid a fee for your work, and then there is a royalty structure, and the percentage of your royalty is something to be negotiated, but it is for future work of future showing of your work. So if in the contract the production is to exist from January 31st to March 1st, you're getting paid your design fee for that. And then any production subsequent to that that is produced by the company on the contract, you are paid a royalty for the use of your intellectual property. So for example, I design a show for the Canadian Stage Company. The contract is with the Canadian Stage Company. The Canadian Stage Company then chooses to show my work again at a later date that is beyond the terms of set forth in the contract for the original production. Then I would get paid, let's just say I negotiated a 2% per performance royalty. That would mean 2% of my original fee per performance for the showing of or the use of my intellectual property. If, let's say, however, and here is where there is a lot of confusion or misunderstanding. If, let's say Alberta Theatre Project decides that they want to produce the Canadian stage production of that particular show. If Alberta Theatre Project was not named as a co-producer on the original agreement, The Alberta Theatre Project then has to either, one, re-engage you, or engage you, sorry, not re-engage, engage you as a designer with a brand new contract, as they are not party to the original contract. The original contract, it's very clear, is not transferable. So the Alberta Theatre Project would then either have to engage you with a new design contract or negotiate with you a licensing fee for the use of your work. In my experience, this is where the grayest area lies. The contract is not transferable. The only obligations you have are to who you have the contract with. If Alberta Theatre Project did not sign the original contract, if they are not a co-producer on the original contract, you then have no protections when it comes to the standards that go along with that contract. So for those of you who are familiar with an ADC contract, it's, I don't know, 4 or 5-ish pages long. The standards are 29 pages. So that is what accompanies the contract, those standards, and the use of intellectual property is part of that. There are companies, let's just say the original contract, Canadian Stage, and the Alberta Theatre Project were co-producers on the original contract. Then Alberta Theatre Project could potentially continue the use of your design moving forward. However, unless they were an original producer, they have to re-engage. So there are companies like, let's say, the National Ballet of Canada, who may want to extend the terms of the contract at time of signing. Sometimes the National Ballet of Canada will decide to pay you a lump sum as for the use of your design at any moment for, let's say, a 5-year period. That is something that can also be negotiated, but they cannot then transfer the rights of your design to anyone else. There are a number of situations where I've had a situation where I created a show at Theatre Passe Muraille. The show was then presented at Canadian Stage. Theatre Passe Muraille was no longer involved in the show, and therefore Canadian Stage then had to engage me under a new design contract. That particular show, Canadian Stage then decided to not be a part of it anymore, and Necessary Angel picked up that show, and I then had to be re-engaged by Necessary Angel. In all 3 of those instances, I was given a new design contract instead of a licensing fee for the use of my design. Now, a small alternative to this is going back to the original example that you did a show at Canadian Stage, and ATP wanted that show. If Canadian Stage continued to pay you, so they paid you your royalty and the time required for you to continue on with the show at ATP, that is fine because Canadian Stage is still the producer of that show. However, again, the rights cannot be transferred to ATP and ATP pay you. So it's as simple as who is the producer and who are you engaged by? If you continue to be engaged by the Canadian Stage Company, then the term of that contract is 3 years. If Canadian Stage has set aside that production and is no longer involved in the producing of that show, the new producer needs to engage you either as a designer or a licensing fee for your intellectual property. So before I continue, are there any questions? Okay. When we're talking about digital contracts, it's very much the same as our live contracts. The contract that we currently have, both with PACT and the Indie contracts and the NAC agreement, it still exists in this digital age. So when we're discussing intellectual property when it comes to the digital broadcast of a show, there is a section within our contract, both in the PACT, the Indie 1, Indie 2, and the NAC agreement, regarding broadcasting rights. And so our broadcasting rights are fairly clearly set forth. It's very different than with the actors. Actors, when it comes to any kind of broadcast, their rehearsal section of the show goes through equity, and their broadcast version goes through ACTRA. For us, the broadcast rights are embedded within the contract, and there is a bump within the contract for the broadcast rights. What's important to consider when you're negotiating the term of the broadcast rights, it's important to make sure that is clear. Certainly in the PACT contract, the broadcast rights it is left up to both parties to determine the length of that. You might decide in the PACT contract, there is a 40% bump. So 40% of your original fee allows the producer to broadcast your work. You can then negotiate whether or not that is for forever, or if it's a 3-year term, much like the contract is, or if it is the term of the length of a regular production that is done live. That is a point that you should negotiate with the producer at the time of signing the contract. The Indie 1 and Indie 2 have a different bump when it comes to digital broadcast, but those percentages are embedded in the contract. So it is in addition to the design fee that you've been paid for the work is the broadcast bump. And part of that is your intellectual property. It's very clear how many eyeballs, or the maximum number of eyeballs, that are going to see your work when it is live. The bump is a recognition of broadcasting. And the broadcast could be international. It could be an open free stream, or it could be behind a paywall. These are aspects that you can get as a designer if you're concerned about the presentation of your work, the length of time, or the platform with which it's going to be broadcast. It's important to understand that, understand what you are negotiating, and understand how many platforms it might be open to. The difference between being behind a paywall and being free, much like this stream is free for people to watch. There's a lot of difference there. So the protection of your intellectual property is trickier when it's a full open live stream. Is there any questions with regards to digital broadcast of your intellectual property? No questions so far. So an overview: your intellectual property is your art, lights, costume, set, video, sound, your work as a whole as a designer. So what you've brought to the project, what either visuals or audible work that you've brought to the project, that as a whole is your intellectual property. Very recently, there was a digital show that was created, and portions of different people's intellectual property were used. And so there was a separate agreement made between that producer and those designers with regards to their intellectual property. For example, one of 97 costumes got used. And so they paid a royalty for that one costume as opposed to the design as a whole. So your intellectual property is your work as a designer on a show, whether it's live or digital. that intellectual property belongs to you. Um, your intellectual property agreement is with the producer who has signed your contract. That your intellectual property is not transferable from producer to producer. As long in a co-production agreement, if multiple producers are named on that contract, then your intellectual property has been licensed to that number of producers named on that original contract. If someone would like to use your intellectual property who is not party to your contract, a new contract must be signed, whether or not that's to engage you as a designer in your design services, or whether or not that is to license the intellectual property that you've created already. They are not party to your original contract and therefore can't hop on and just pay the royalties that were set out in that original contract. When it comes to digital broadcast, whether you're using the indie contract or the pact contract, there is a clear indication of what that bump is from your original fee in order for a producer to get the broadcast rights to your work. When it comes to non-ADC members, obviously there could be a number of you listening to this right now. It's important that you consider all of what I've just talked about. The term of your contract, the royalty that you would get paid subsequent to the dates laid out in your contract, and if there is a broadcast of your work, is there any question? No questions. Interesting. There isn't much more to talk about unless people have specific questions with regards to their own intellectual property or questions regarding specific contracts. I'm surprised because it is the topic where I get the most questions in general.
Yeah.
Hi, Andrew.
Hello. Yeah, well, considering the delay in things that sometimes the questions will start coming in later, but can you actually just repeat your last point? You kind of chopped out
Okay.
right before you asked questions. Yeah.
With regards to non-ADC members,
yeah,
things that they should consider within their contracts is the term of their contract, whether it's 1 year, 2 year, 3 years, and making sure that if the show will be broadcast digitally, making sure that that is also covered in their contract and having an understanding of how and where it's going to get broadcast and for how long. How much work should I be doing based on a royalty? That's a great question. So the royalty is, let's just say you've negotiated 2% of your original fee per performance. That is for the work that currently exists. That is not for additional work. So in an ADC contract, there is an additional services clause. So if there is work to be done, let's just say for myself as a lighting designer, certainly every time a show goes out, I have to plot the show. If I'm going with the show, then my time is being used to go with the show. Or if I have to teach someone the show, my time is being used to teach that person the show. So any work that is beyond the original design, you should be negotiating for your time based on the additional services clause in your contract. So the royalty does not pay for any of your time. The royalty is the use of the intellectual property that exists. If there's redesigning to be done, that should be negotiated. If there's drafting, let's say for a set designer to plop the show into a venue, you should be being paid for that time in order to do that work. If you have to show up at the new venue, then you should also be being paid for that. When it comes to digital work, if you have to make alterations to the current the current design that you already have, you need to be paid for that time. So just to be clear, the royalty is for the use of your intellectual property in that, in its entirety that's already been completed. Anything to consider? Sorry, Andrew, go ahead.
Oh, I was just going to ask, like, what specifically as a percentage? What's a good royalty percentage for?
Well, I think that's an individual consideration. 1 to 2% is often the norm within the Canadian community. Let's see. I think I missed one. Anything to consider for protecting your intellectual property if you do something non-commercial that then transitions to be used in a commercial setting? I guess the question here would be, did Canadian Stage do it in a not-for-profit way and they have then moved to a commercial setting? Or is there a new producer? Obviously, if there is a new producer, a new contract should be considered. If you believe, what is difficult is if your work was originally with, especially in Canada, with a Canadian company, almost all of them are not-for-profits. So the transition to commercial is not very often. I have certainly done shows that have been presented and then the Mirvishes, let's say, have picked them up, but that's always produced a new contract. So if you're moving into the commercial world and there isn't a new producer, that's not very often, but I would consider looking at trying to renegotiate your contract. Let's see what is next. With a new producer taking over a design, how do we negotiate between a new design contract and a licensing fee? Is there any ADC templates for licensing fees? Not currently. There is not. In my experience, every time I have had a new producer come on board, I have had a new contract. It may not be at the same level as, it might not be at the same value as what, let's just say the Citadel picked it up. And let's just say, normally from the Citadel, I get paid X dollars. This new design contract might not be X, let's say $8,000. This new design contract might be $6,000 instead. Of course, it can't go below minimum, but there is a recognition there that I'm not fully redesigning the show. In terms of a licensing fee, you have to consider a licensing fee is just the use of your work. So if you as a designer have to go there and show up and do a bunch of work, like let's say a costume designer has to be there for 3 weeks for fittings, I would consider a design fee versus a licensing fee. A licensing fee would just be, you know, here are all the show files for the sound, and there you go. In which case, you as a designer have to consider what is the correct value for you when it comes to the use of your work. And the use of your work, I would encourage the use of your work is greater than just a royalty per performance. Your intellectual property, the time it took for you to come up with that design should be recognized in your licensing fee. Does your intellectual property guarantee your involvement in extra work in the future? Let's say I have a contract again, Canadian Stage, and and as a lighting designer, they're deciding that they're going to do that show, and they're going to do a big European tour of that show, and they're going to hire a lighting director, let's just say, to take it on the road. And I am not going to be taken on the road. So certainly there's a discussion to be had I usually say in those instances, I would like to have a little bit of involvement as to who that person is. When you design for the opera or for the ballet or in a lot of those larger entities, they have someone like that on staff for the work. And so although you're not guaranteed to be going on the road with that show, any alteration to your work, you must consent to. So if you're not going, let's say as the set designer, you don't get to go and see the set in place. That is often the case. You're getting paid a royalty, but it's important that you have open communication with the producer to make sure that your work is being presented as it was intended. And any change to your work must be a consultation with you. It's important to also understand that within our standards, we cannot unreasonably withhold the permission of the use of our intellectual property over that 3-year contract. So open communication is very much important. And making sure that your work is being presented in the best way possible. But as we all know, when a show, let's say, is going on tour, you can't necessarily be contracted, or you may not be available to go. So making sure that it is presented in the manner in which it was intended is important. So open communication with the theater. And if changes are being made, you need to either be engaged to do those changes, or they need to get your permission in which to do those changes. So it depends on how big the change is. Like, are we just moving the set a little bit in terms of its rotation to the audience? Or are we looking at cutting a third of it away and redesigning? If there's a redesign involved, it is your intellectual property and you need to be engaged for that work. Question, I'm starting a new theater company and am new to forming contracts. What are good contract standards to uphold? Well, I would suggest that when it comes to designers, you are more than welcome to get a copy of both the Indie 1 and the Indie 2 from us. That I think in the Indie, there's 32 pages of standards. Anyways, it would be good for you to look through those standards and be in contact with the office if you have any questions. Terms of the contract are very important. Expectations. So it's very clear in our standards what the job is of, let's say, a lighting designer. So understanding the expectations and what it is that you are contracting that person for. There are also clear minimums, and it's important for me to also point out that minimums when it comes to design are very different than minimums. Well, I would say very different than minimums when it comes to actors, but I'm not even going to compare them. Minimums when it comes to design, it's clearly set out that for the minimum, these are the things that will come with that minimum. If you are looking for a greater time involvement from the designer, then it's important to sit, negotiate, look at the time involved, look at what you're looking for. Certainly with our contracts, the minimums state that we are responsible to attend tech and the first public performance, and beyond that, we are not obligated. We're obligated to be available for phone call, but not necessarily in person. So I would encourage you as a new producer to get in contact with all of the associations that represent freelance people in the arts and collect those contracts so that you can look at the standards involved and make sure that you include those in your contracts. Certainly, if you are going to engage an ADC designer, you would have to use one of those contracts. If you're not using an ADC designer, I would encourage you to look at those because I believe those standards should represent and support even those non-ADC designers. The pandemic has increased the frequency of digital broadcast of live performances. Has this increased the use of digital broadcast affected or to my knowledge, no. There's been a lot of question regarding the digital broadcast section of our contract. But what we have not seen so much of in the office is the understanding, a lack of understanding of intellectual property for designers. I don't know if I'm answering your question properly or correctly. I'll move on. And if you want to put a follow-up in there, that would be great. When you negotiate a contract, are you being paid for your intellectual property or for your time? That's a great question. So when it comes to designers, I think different producers feel differently, but ultimately you're being paid for both. And that's where the negotiation comes in. So you're being paid for intellectual property and for your time, because there is a certain amount of time where you are required to be there. If you were only being paid for your intellectual property, you would never have to show up ever at the theater. Well, some of us would, lighting designers would, because you can't create your work without going there. However, so your time is part of that. And that's where a bit of negotiation comes into play. Negotiation, the size of the show. You should consider that as a designer. The required time where you are required to be at the theater. You should consider that. You know, some shows have a week and a half of tech and you're done. Some shows have 4 days of tech, and some shows at the region, at some of the festivals, you're back and forth for months. And so these are all things to consider when negotiating the value of your contract. Question: does every gig need a formalized contract? I would say yes. I think something that the pandemic has underlined is that without a formalized contract, you have zero protection. You have zero protection in terms of what was agreed upon in terms of remuneration. When it comes to intellectual property, of course, there are intellectual property laws that do exist. It is easier if you have a contract in place. I think it's important that although we do shows with our friends, a number of the institutions we work with, we've developed very friendly relationships with them. However, I think it's important, this is business, it is art, it is also business. I think it's important that on both sides, both from the producer and from the artist or the designer, understanding the expectations of both sides can be laid out clearly in a contract, and this can then remove any questions with regards to expectations. So managing both sides of the contract, both the engager and the artist, it's important to understand the expectations of both. And so if there's just an email chain or there was a verbal conversation or whatever, there can be misunderstanding and all that. And so if we just write it down on paper and we're very clear, then there's greater protection for both sides, making sure that you've done what you've agreed to and making sure you get paid for what you, for the work that you've put in. If a production has been taken over by a new indie producer, but the show will be presented in a packed house, do we use an indie contract or a packed contract? You use an indie contract. So if I'm being engaged by theater company XYZ, if my contract is with theater company XYZ, but they've decided to do the show at Berkeley Street at Canadian Stage, Berkeley is not the engager. Theater company XYZ is the engager. So theater company XYZ has to be the engager for all the artists involved. You sort of can't split it between actors and designers. We're all engaged by the same people. If both the Pact Company, Canadian Stage, and Theatre Company XYZ are named on the contract as co-producers, it has to be on a Pact contract. That's clear in the standards. Any other questions? I'd also encourage any of you, if you have questions moving forward, whether it's regarding digital contracts or whether it's regarding contracts for in-person work moving forward, you can always contact the ADC office, which is adc@designers.ca. You can contact the executive, which is executive@designers.ca. You can contact the president, the treasurer, or the vice president at the office as well. And that's president@designers.ca, treasurer@designers.ca, or me, VP@designers.ca. So you can certainly contact any one of us if you have questions, both if you are a designer or if you're a producer. We're happy to answer any questions you might have.
Hello again. Thank you for all that. I don't think that there's any more questions. So I think we'll wrap it up here. We have our next event coming up soon as well. So thank you so much for your time. Thank you for bringing all this up. It's all very important information, and we got a lot of questions. Obviously, there's probably still more questions, but those will probably come later than the people that are going to watch the archive. So
great.
Yeah. So
thank you.
Yeah. Thank you so much for coming on. Thank you for your time.
Thank you for all attending.